Good morning and welcome to the Law Show. We're here every Sunday morning, responding to text messages we've received either on the air while we're on the air or during the week. We try to respond immediately. So if you send us a text message anytime during the show, we try to respond to you quickly. Sometimes we use the text messages to introduce a subject or to talk at greater length about the issue that's raised by the person who sends us the message. So I'm going to start with one of the messages we received. But before I actually do that, one writer responding to the comment about the lawyer's appearance and their hair and eyebrows and whatever the things that the lawyer has little control over, said it really depends on what's between the ears, not what's on top of the head. And I thought, well, I appreciate that. But then later I thought, well, maybe that wasn't a compliment at all. So I just had to rethink that. And I don't think people really appreciate the difficulty a person has that every day they wake up, they have a bad hair day. But really, that's not the best criteria to pick a lawyer for anyway. But why that subject came up, we did get a number of responses to that. But there was a question that I really thought was an excellent question. And we're not seeing so much of this being advertised now, but we just had an avalanche of it before, and I'll tell you what this is all about. The question was, will I lose my insurance if I don't see a doctor for 14 days or go to the hospital? This all started because there were people advertising and saying just that. If you don't see a doctor in 14 days, you will lose your insurance. Well, this is nearly idiotic because you didn't have to have an injury. The comment was you need to go, or the advertisement was you need to go to a healthcare provider, was primarily a chiropractor, to be checked out so that you don't lose your insurance. But can you imagine someone going to the emergency room and saying to the emergency room staff with people in there that are very, very sick, accident victims and others, and saying, I'm here to be checked out because I don't want to lose my insurance. Well, sir, are you sick or are you injured? No, I actually am feeling fine. But I was told that if I don't come in here and have you check me out, that I'll lose my insurance. Well, of course, that was insane. Okay, another way to say it. But what were they talking about? What was the pitch that they were aiming at with this advertisement that said you're going to lose your insurance if you didn't get to see them within 14 days? There is a kind of insurance that everybody is required to have. It's archaic and almost useless, but everybody in Florida is required to have it and has been for the last 30 years. It's called PIP, Personal Injury Protection. And it is in the amount of $10,000. That's the maximum PIP that you can have. And you're required to have it. Well, what is PIP? PIP pays for lost wages or health care regardless of who's at fault in an accident. All right? Now, $10,000 hardly gets you a Band-Aid in the typical emergency room bill. So the $10,000 is only really beneficial to people who've lost wages and are not going to get their wages covered quickly so they can receive that money. That's really the only benefit of PIP, because $10,000 is nothing in today's medical care costs. It just is insignificant. That's what they're saying you would lose if you didn't see a healthcare provider within 14 days. That's PIP. It's not all your insurance. It's not your MedPay. It's not your uninsured motorist coverage. It's not anything other than The PIP. You would lose the PIP if you didn't see a doctor within 14 days. Well, if you're not injured and you have no symptoms from being in an accident, why are you bothering to go to a healthcare provider? Well, it's they say, to protect this PIP. You want to be sure and get this PIP. Well, here are the numbers, okay? And I'll tell you how the legislature addressed this. But if you had 100 people that were in an accident but were not injured, that's the vast majority of accidents, by the way. People are not injured. They might get a bruise or something, but they're not badly injured. That's most of the accidents. But let's just say that you had an accident and you were one of many who went to the healthcare provider and said, check me out, and I have this $10,000 available, and I'm here within 14 days. Well, if you have 100 people that basically are fine, nothing wrong with them, but they go and get, quote, checked out with the x-rays and examination fees and all of that, and there's a $10,000 pot of money there that the healthcare provider gets, and you did 100 of those, that would gross $1 million. So that's why we had all these advertisements saying, oh, terribly, the sky's falling in if you don't see us within 14 days. Well, the legislature recognized the gross abuse of that and limited certain healthcare providers to $2,500. That's the maximum they could charge. So you don't see these ads like you saw before. There are still some of them out there. And what the ads should say, if they were truthful, is that you will lose your personal injury protection, $10,000, if you don't see a healthcare provider in 14 days. But if you're not hurt or you're not injured, why are you bothering healthcare providers by going to them to be, quote, checked out? By the way, we had somebody that we knew was a friend of our family's, and she came to us and said she'd been to this certain healthcare provider, and they did a whole series of x-rays, as if that was some diagnostic benefit. Well, it's a detriment to you to be exposed to x-rays. If you don't have to have an x-ray, why in the world would you do that? But she thought it meant that was a very thorough examination. But she was fine. She had low back pain. All right. My brother, who was with us for many years before his death, was the ultimate observer of phony medical claims, and cautioned us repeatedly in our cases to be sure that the case was meritorious and that the person was generally hurt, and to verify that before you went on. But he would tell me that with many ligament injuries, it takes about 6 weeks because of the poor blood supply to that area of the body, whatever it might have been, before you get well. So when people race to a doctor with a sore, whatever it is, knee or elbow or arm or whatever, and they get, quote, treatments, whatever they might be, massages or whatever it is, not really real medical treatments, but provided in these little offices around. So they get better and they think, well, that's why I got better, because I went and got these treatments or whatever. Truth is, they were going to get better on their own. So what is PIP? PIP is part of your insurance that you're required to have. Florida is really, really bad about this. In Florida, the policy of our legislature is they want to protect property first. That's number one. Whether you get injured or not, that's secondary to them. They want to protect property claims, okay? So in Florida, you're required to have property damage insurance, right? but you're not required to have liability insurance. So if you hit somebody and cause damage to them and harm them, your insurance will pay for their property to be repaired, but not for their injury that they've sustained. You personally are exposed to that. Mike McLeod covered this at length, but Florida is one of the only states in the country, all the states in the Southeast require bodily injury protection coverage. And the bodily injury protection coverage is in case you hurt somebody, that you have insurance that will protect them, not just their car or their property, but will protect them. Florida should adopt that, but there's a real pushback in Florida by the legislature protecting insurance companies and protecting the interest of property as opposed to the interest of people. And it has never gotten off the ground in Florida, although year in and year out they try to have bodily injury protection coverage required in Florida, which it should be by all accounts. It's required throughout the Southeast in virtually every state in the country. So that's the Florida story. And it is a function of the power and the influence of the insurance industry that is pervasive in Florida, has been and will be, and particularly when you have one party, which we have in Florida, that runs everything, then they just have to go to one central place and put the pressure on to make the recoveries that they or make the coverages that they want to provide, the law of the state. And that's what's happened in Florida. So what do you need? As I say, Mike McLeod covered this, I think, in a previous law show, but I was going to highlight it. Depending on your financial situation, you buy insurance to protect you in the event you cause a bad injury. And if you have substantial assets or wealth and you want to protect them with as high a liability insurance limits as you can get. But there's another reason to get them. Say 100, 300 coverage or 300, 500 coverage. We'll explain more about that. But you want substantial coverage if you can afford it. For this reason, you can obtain the same level of insurance to protect you and your family as you buy to protect other people. So if you buy a 300,000 / 500,000, 300 per person, 500,000 for everybody that's injured in an accident, that's available if you have uninsured motorist coverage. That's available to you and your family in the event that a drunk who's uninsured rams into your car and causes you or your family a bad injury. You want uninsured motorist coverage. It is imperative that you get it. You can only get it to the extent of the bodily injury coverage you provide that protects other people. So if you buy $10,000 bodily injury coverage, you can only get $10,000 uninsured motorist coverage. Uninsured motorist coverage is critically important for people to get to protect their families. Look at your policy right now. We're going to close out here in just a second in this first segment, but I'll add this. You want it stacked. Don't ask me why right now. You want it stacked, which will double or triple depending on the number of cars. You have 2 cars, it's doubled. 3 cars, it's tripled. You want stacked uninsured motorist coverage. You want to get as much as you can, which means you've got to buy as much BI insurance as you can afford, bodily injury coverage. Bob Kerrigan for the Law Show. After this short break, we're going to be back, and when I come back, I'm going to talk about some very interesting medical issues that I think will be of importance to you. So stay tuned. I'm Bob Kerrigan. Have you seen the young lawyer advertising standing on top of a truck? I wonder who he would hire if he fell off the truck. Maybe the lawyer who has hundreds of billboards up and down the interstate. If it happened in Florida, though, it couldn't be him because he doesn't even have a Florida law license. He wouldn't hire the lawyer who barely has time to eat with his family because he just seems too busy. Maybe the lawyer who busts down his office wall, but that may not be a good place to be if another wall is crashed through. If he called us, we'd tell him it wasn't the brightest idea to climb up on top of the truck in the first place. With the highest ethical and legal ability rating from Martindale-Hubbell. We represent one client at a time, and we've represented thousands of clients over the years. Your case will be handled by a board-certified partner, board-certified in civil trial by the Florida Bar. Kerrigan, Estes, Rankin, McLeod, and Thompson at Kerrigan.com. Welcome back to the Law Show. Bob Kerrigan with you this morning. And thank you very much for all of the text messages that we have received. And we also receive emails that you can email me directly if you want to. It's just bob@kerrigan.com, bob@kerrigan.com. And I'll respond to the email. If you ask us about something that we don't do in an area of law that we are not specialist in, we'll try to get you referred to somebody that in your community, wherever you are, across North Florida especially, that has the expertise in the field that you have a need for. We've had questions about wills and trusts and things like that, which we don't do, but there are very fine lawyers available that will help you. And despite the public sentiment, which is largely a response to some ethical, unethical things that lawyers have done, lawyers are the brunt of bad jokes. We call them bad jokes. Most people think they're really funny, but anyway, the lawyer jokes are pervasive. Why? Because nobody likes their lawyers generally. I say no. Very few people just like lawyers generally. Those lawyers, they're just great people. I mean, you might say that about architects, for example, or you might say it about CPAs, or you probably wouldn't say it about CEOs, but you might say it about a particular kind of real estate people. They're really wonderful people. They care and they engage with their customers and all that kind of stuff. They don't say that about lawyers. People don't like lawyers generally, as a general statement. But they like their lawyer. They like their lawyer because their lawyer's looking out for their interests. They just don't care about the rest of them. Okay? So, but wait just a second. If everybody likes their lawyer, then we kind of have a wrong image of what lawyers do. And what lawyers do is protect the interest of their client. Now, ethical lawyers separate out their own interest from the interest of their client, their own financial interest from the interest of the client, or any conflicts of interest. And you probably have heard this before. If a lawyer has a conflict of interest, they'll say, here's the reason I can't give you 100% loyalty. But the lawyers are there to advocate for their clients within the bounds of the legal profession, the rules that they follow, the ethical principles that they have to adhere to. And we have a very, very good disciplinary system for lawyers that act unethically or improperly. I'm not so sure that's true about the legal profession regulating politicians who are lawyers. I think they've been grossly deficient, allowing lawyers who are elected officials to do just outrageous things, and the various bar associations, including Florida, don't do anything about it, and they should. But we have a very good system otherwise for lawyers that act improperly. There is a way for the Florida bar to address that, and if that has happened to you, you can file those kind of complaints with the Florida bar, and they'll look into it for you. They do a very good job with that. But as I say, they're just weak on politicians, and the problem is, they need politicians to a certain extent, and so they cut them probably more slack than they should. But it's gotten to the point now where elected officials that are lawyers who say the most outrageous and unfair and even dishonest things, nothing really happens to them. Okay, Ashley Moody, for example, ran an advertisement, in a political advertisement, where she made statements that were not true. These are not true. And the statements that she made were in a political ad. Now, they later pulled that political ad, but she was the Attorney General of Florida when she said that. And of course, there is an argument that she should not have intervened in a lawsuit that the Supreme Court found to be meritless, but that's another issue altogether. All right, so now we're on to some other subject for a minute. And this is, my source is something called MedPage Today. I really like this site. These are doctors that write about various medical issues. And this particular article, I'm going to cover two subjects actually in this segment of the show. But the first article I'm going to talk about is titled "Beware of Health Insurance Brokers." Okay, so here's the highlights of this, and I'm going to read from it. And it's by Katie Talento and Gay Ba, B-A-I, PhD, So here's the thrust of this, and this is for employers primarily. This particular article I'm talking about is aimed at employers. Health insurance brokers market themselves to employers as a buyer's agent, promising to use their expertise to find employers the best deal for health insurance. A new study, however, reported a positive association between the health insurance broker commissions and premiums paid by employers offering fully insured group health plans to their workers. What's more, brokers are also paid various types of bonuses by insurance carriers based on the amount of total business the broker has placed with the carrier, the amount of new business delivered to the carriers, or other types of metrics based on profit delivered to the insurance carriers. Back to the evil insurance companies, okay? Really at the heart of everything where there's a lot of money involved, we find the insurance companies. If you're an employer, this article goes on to say, for a fully insured health insurance plan, your broker has every incentive to sell you a higher price plan compared to a lower price plan. A plan structured to produce more profit for the carrier rather than savings to you. A plan sold by the carrier that has a better bonus structure compared to a better plan for you offered by another carrier. Larger employers often hire one of a handful of major insurance carriers to administer a self-funded plan. What's wrong with that? The answer is, what incentive does that carrier have to make sure the employer isn't being overcharged, billed erroneously, fraudulently, or billed for inappropriate and unnecessary care at more expensive sites of care? What's the disincentive? There's none. Okay? So fully insured employers buy plans sold by agents who have no incentive to keep costs down or recommend the most suitable plan. Self-funded employers, we just talked about, have carriers that have no incentive to keep costs down or quality high. What are employers to do? The article says. First, smoke it out. Fully insured employers should ask their broker to disclose all dollars flowing to them as a result of the employer's business, including all commissions and bonuses paid for health plans as well as for ancillary lines such as disability or life insurance. Second, self-fund employers may want to enter into a direct fee arrangement with their broker who would receive no commissions from any carrier and instead is paid a flat rate, a per subscriber per month rate. Okay? Our healthcare broker status makes service providers, brokers, and insurance carriers do better financially when patients are sicker and charge higher prices. Rehumanizing employer-sponsored health benefits and require competition on the basis of delivering the highest quality care for the lowest possible cost is the goal we should have. The only way this will happen is when all the incentives in the supply chain, including brokers and carriers, are realigned to the best interest of employers and their workers. I highly recommend this for employers that may be dealing with this issue, and it's from MedPage Today. All right, another article from MedPage Today, which I found really interesting. Well, actually two articles, but one I found very interesting dealt with e-cigarettes. So I'll pass that on to you. If you're trying to quit smoking and you're smoking e-cigarettes, what's the latest on this? Okay, adults who used e-cigarettes and smoked cigarettes, which is what generally happens, they do both, had similar levels of inflammation and oxidative stress predictive of cardiovascular disease, and exclusive cigarette smokers as exclusive cigarette smokers in an analysis of data from the Population Assessment of Tobacco and Health study, meaning that they had the same potential harm as people who just smoke cigarettes. So you say, well, I smoke e-cigarettes and I smoke like 5 times as much e-cigarettes than regular cigarettes. The studies early indication are it's just as bad as if you smoke just cigarettes, okay? These cigarette guys, I say guys, you know, I always think women have higher standards than some of the businessmen that are involved in cigarette companies. I don't know if that's true or not. It's kind of a chauvinist view, I guess, of things. But these guys are really clever at figuring out how to sell cigarettes. Okay, so you through these various e-cigarette companies, they pitch out these e-cigarettes, and people are sitting there smoking them, and they think, "Oh, yeah, it's not hurting me, it's not hurting me, it's not hurting me, so I'll go ahead and smoke a cigarette tonight. I'll enjoy it after dinner. I smoke a couple of smokes." Well, as it turns out, it's just as bad for you. Okay, they are always at it. You know, when we entered into the final agreement with the state did with the tobacco industry, the state made a mistake by allowing the point of presence displays for tobacco, and that's why they're all over these convenience stores, every place. I mean, they're just every place you can see. It's an awful thing. Cigarettes cause so much damage and so much harm to our society and to our healthcare system. Many studies have shown that you smoke cigarettes, you have all kinds of complications from disease for sure, but in terms of just getting better, you're delayed getting better. If you smoke cigarettes, you have a higher incidence of other problems that result because you're a cigarette smoker. You're in the hospital longer. Healthcare costs are more, and on and on and on. It's just an awful, awful habit. It is not inconceivable in this country, but it would be the public policy of this country to eliminate them. Okay, no more cigarettes. We give you a year. In a year, everybody's going to quit. We're going to take them off the market, and we're not going to have them here because they're poisonous. They're actually poisonous to the human body. The analysis of this data with study participants surveyed in 2013 and 2014, it's among the first nationally representative analysis to explore the cardiovascular toxicity of electronic cigarettes use by measuring biomarkers known to predict heart attack, stroke, and other cardiovascular events and strokes. A study appeared in the American Heart Association. So I just will conclude this by saying that the overwhelming evidence is right now that the predominant way e-cigarettes are used is in combination with cigarettes. It's just as bad as smoking cigarettes themselves. This is from Saylyn, Saylnn, Bowles, Bolyes, who's a contributing writer for MedPage Today. I really like this MedPage Today, as I mentioned, because I think the articles are really helpful and they're understandable by us. We're not medical doctors, and we don't understand all of the medical aspects of some of the more technical journals, the American journal, various journals that the specialists have in the field of medicine. But this is written more for lay people to understand it, so I highly recommend it. And there's an article, I'll just tell you quickly, by Dr. McCary saying that what Ron DeSantis is doing in Florida is the European model, is the best way to administer COVID-19. So credits to Governor DeSantis for his approach to the administration of the COVID-19 vaccines that are going to be available to the public. Bob Kerrigan with you. Encourage you to send us a text. You can send us a text right now while we're on the air, or you can email us or communicate with us otherwise. And thank you for watching The Law Show. Bob Kerrigan for Kerrigan, Estes, Rankin, McLeod, and Thompson. What is medical malpractice? In many ways, it's similar to an auto accident. If a driver of a car is careless and causes an accident and injures someone, the driver is responsible for those injuries. If a doctor or employees of a hospital violate the rules of medicine, they're responsible for the injuries they cause. These rules of medicine make up the standard of care that doctors and hospitals are required to follow. Medical malpractice cases are expensive to bring and can be very difficult. We're required to retain qualified medical experts to assist the jury in understanding why what was done violated this standard of care. At Kerrigan, Estes, Rankin, McLeod, and Thompson, we accept meritorious medical malpractice cases where substantial injuries or a death have been caused by a doctor or a hospital failing to abide by the rules of medicine. Please see our reviews on our website at Kerrigan.com.
Welcome back to the Law Show, brought to you by the firm of Kerrigan, Estes, Rankin, McLeod, and Thompson. I'm Randy Thompson, one of the board-certified trial lawyers at the law firm. And in this segment, I'm going to talk to you briefly about what your lawyer ought to be doing for you in an automobile accident case. First and foremost, it is all about credibility and truth and honesty about our client's injuries. If an insurance adjuster, or if we can't get the claim settled, then we have to go to a jury trial. If a jury believes that the plaintiff, the injured person, is not being honest, is not being accurate about how the accident happened, or about what the injuries are, or how the injuries impact them, then the case is over, because no jury is going to help somebody who they don't like. So what we know as board-certified trial specialists is that you must be credible. You cannot overreach. You cannot exaggerate. You cannot minimize, certainly, but you must be honest. And you must have all of your credibility intact, so that 6 people on a jury think, well, this is a worthy plaintiff. This accident really has impacted this person and how they go about their daily life. On the way into the studio this morning, I received a phone call from one of the doctors in our area. Because we've been doing this for so long, we have a lot of relationships with doctors. We know them. We've taken their testimony in courtrooms. We've met with them in their offices so that they could explain the medicine to us. But one of the things this gentleman said to me this morning was he just wanted to take the time to thank my firm, the members of our firm, for being so candid and for being so upfront about our case. He made it very clear that not all lawyers do the same thing. This law firm would never refer one of our clients to a particular doctor for treatment. We believe that that is a medical decision that is best made by the injured person. It's best made by the person who's having the treatment done. So you should talk to your family members or your coworkers about what doctors they like and what doctors have helped them with similar aches and pains. Your lawyer's job is not to find you an attorney. And what happens is when it gets to an insurance adjuster to try to settle the claim, or when it gets in front of a jury and the jury finds out, and they will, well, how did you go to this doctor? Why did you pick this particular doctor to go to? And when your answer is, well, my lawyer told me to go to him or her, my lawyer sent me there, it just smacks of not being honest. It smacks of there's something fishy here. And there doesn't necessarily have to be that, but it's the appearance of impropriety. It's the appearance of trying to put together a claim that may not be valid. If, on the other hand, you pick the doctor because he's been your family doctor forever, or you pick the doctor because your family doctor suggested that you go see this new physician and she has now taken over your care, all of that makes perfect sense. What I tell my clients is, I don't care what kind of doctor you go to or who you go to. I just want you to go to somebody that you have confidence in, that you believe can help you get physically better. And I encourage my clients to not talk to their doctors about the lawsuit or the claim or what's going on, because the doctor truthfully doesn't have any impact in that. The doctor's role is to just try to make you physically more comfortable and to get you back on track to where you were before this car accident. So we like to keep the doctors out of the legal aspect of it. I like to have my clients not talk to their doctors about the legal aspect of their case, but rather, doctor, get me better. I'm feeling much better now. That's working. This isn't working. Talk to them about if they prescribe medications, how the medications are impacting you. They're doing great. They're not doing great. They're making me drowsy. But not about, listen, will you write a letter for me for my lawyer so that I can get the insurance company to compensate me? When those kind of conversations get into your medical records, it sends the whole wrong message to either an insurance company or a jury about why you're there and what you're trying to accomplish. So from a straight up car accident or any type of accident, this law firm, the Kerrigan law firm, and the partners in this law firm would never suggest a particular type of doctor for you to see or not to see, because that's a decision that you should make based on your own intelligence. Some people, for example, believe in chiropractic care. Others don't believe in chiropractors. It's up to you. If you think chiropractic care can help you get physically better, then that's where you ought to be. Not because some lawyer told you to go there because he plays golf with the chiropractor, or or they're in some group together, or they're neighbors. That's not why you should go. You should go to get physically better. And if you don't believe in chiropractic, then go check with your family physician and see if he or she can refer you to another type of doctor to help you. Okay. So I kind of went on a rant there about that. Probably because the doctor called right before I came into the studio. But in reality, it is a really bad idea for you to go to a doctor because the lawyer told you to go and use that doctor for treatment. I will say this. There are doctors who we hire to do an independent evaluation of your medical records. And so in those cases, I might have my client go to a doctor for a visit so that the doctor could examine them, review all of the medical records, and then give me an opinion about what the future holds or what the nature of the injuries are and how they play out in a particular case. But that's the only example that we have of where we would send our client to a doctor, but it wouldn't be for treatment. It would be for a one-time evaluation, examination, so that we could have a better understanding of what's going on with our client. So that's my concept about that. Car accident cases, in the state of Florida, it is your car insurance that's going to pay the first 80% of your medical expenses. That's what's called Florida no-fault law. And under Florida's no-fault law, you can go to any doctor that you want to go to as a result of the accident. You don't have to have pre-approval from your car insurance. Now, some doctors say, look, we don't take car accident cases, and that can be. So you have to do a little more shopping around. And the shopping around, again, you should do is based on your own experience and your own belief and your own knowledge of what the various doctors can do for you and your thought process about how to heal. But it's your car insurance that's going to pay for the first 80% of the medical bills up to $10,000. It also will pay any lost wages you have as a result of the accident, 60% of those lost wages. Most people don't understand that in Florida law, that we have this no-fault concept, that you can be in your car, paying attention, complying with all the rules, sitting dead still, somebody else rear ends you, and all of a sudden it's your insurance company that has to pay the first $10,000 of your medical bills and lost wages. The reason we have that law in the state of Florida is because the insurance companies wanted it that way. It was their decision. They thought it would make it easier to handle the claims, and they thought you wouldn't seek as much medical care and treatment as you normally would if you know your insurance is going to pay for it instead of the other person's. But that's the law in the state of Florida, and until the legislators change it, you can literally be walking down the street and a car hit you, and it would be your car insurance that has to pay the first part of your medical expenses. You can be treated by anyone you want to be treated by. You don't have to have pre-approval. So you can go to the emergency room. You can go to a walk-in clinic. You can go to your family practice doctor. You must seek medical care and treatment within 14 days of the accident under our new no-fault laws that were passed recently. I say new, maybe 5 or 6 years ago. I have been with this law firm for more than 27 years now, I guess. And this is all we do. So when I say new, maybe 5 years ago, the PIP laws changed and said that you've got 14 days after the accident in which to seek medical care and treatment. And, you know, a lot of folks have an accident and they think, well, yeah, I'm sore, I'm stiff. I should be. I was just in a bad accident, but I think I'll be okay. And they sit around and they wait 2 or 3 or 4 days. And then if the pain is getting worse or not getting better, then you get on the phone and try to schedule an appointment with your doctor. But in light of COVID and in light of the pandemic, maybe you can't get in to see the doctor. But that 14-day time requirement is a very significant time requirement, and you must comply with it. So you don't have to go to the doctor right away, but certainly if you are in an automobile accident case and you are injured and you continue to hurt, you should in fact follow up with a doctor and be aware of that 14-day time limit. Well, folks, I'm Randy Thompson. I am one of the partners at the Kerrigan law firm. It has been nice talking to you all this morning. When we come back after this next break, we'll have more information brought to you by the law firm. The firm is made up of Bob Kerrigan, George Estes, Bill Rankin, Mike McLeod, and myself. We don't have associates. So if one of us agree to help you, agree to be involved in your case, it's going to be one of the 5 of us that are helping you. We're glad to do it. Check us out on the website, kerrigan.com, and you can also email us. You can find our emails on the website. We'll be back.
For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. Welcome back. Again, I'm Mike McLeod, and I'll be with you for this segment of the Law Show. Good Sunday morning again to everyone. The Law Show is brought to you by the law firm Kerrigan, Estes, Rankin, McLeod, and Thompson. Our firm has practiced in the area of accidental injury and wrongful death cases for 40 years throughout Northwest Florida. We've hosted the Law Show for many years, and we're proud to be back on Sunday morning hosting the Law Show, and we hope we provide helpful information to our viewers. Again, our area of specialization is accidental injury and wrongful death cases. Our office phone number, our main line phone number, is 850-444-4444, and I can be texted this morning at that number. I'll get your text, review it, and I will respond to it. That's also our main office number, and my email address is mike.mcleod@kerrigan.com. So over the last couple of weeks, we've been talking about various elements of having a case, what's required to have a successful case. So this part of the Law Show, this segment, I'd like to talk about, well, how do cases get resolved? And, when we ride around town, we see advertisements for lawyers who want to or seeking to get cases. People who are seriously injured in accidents need lawyers to assist them in those cases. But those people want to get their cases resolved. So there are various ways that a case can be resolved, and I want to mention several of them this morning. First of all, cases can be resolved simply by a settlement with the insurance company without a lawsuit being filed, without any more formal negotiating settings, simply by an informal agreement between your lawyer and the insurance company who insures an at-fault person in an accident. And that negotiation between the lawyer and the insurance company should come with the insurance company having been provided a lot of information from your lawyer. And that information includes, in our case, we would put together a package of information that we would send to the insurance company that addresses every element in your case and proves every element in your case. And that would be that their insured caused the accident, and that as a result, our client was injured, and these are the consequences of the injury. So that package of information would include, for example, statements that we've taken from witnesses to the accident that may reveal, for example, in a car wreck case, the other vehicle was, your insured's vehicle was going over the speed limit. Your insured's vehicle ran a stop sign, ran a red light, violated the right-of-way. So we would have statements taken from witnesses who saw the accident that we would include in this information. Sometimes we will also include information, photographs, and of things that play a role in proving that the at-fault driver caused the accident. Photos of skid marks that show how long tires skidded on the road. Photos sometimes of headlight elements proving that the light was off at the time of the accident when an accident was caused at night. All sorts of material things that sometimes play a role in proving that one person versus another caused the accident. So we put together, sometimes we get expert witnesses, people who are trained to investigate how certain elements of accidents happen. And we'll get an evaluation letter from expert engineers that help us prove who caused an accident. So all of that information is included in what we would put together as a settlement package that we might send to an insurance company. Then we want to include information about, well, what did this accident do to our client and how has the client been injured? So we would get all of the medical records that our client that were produced as a result of our client's injury. We would put together documented information about what the client's lost wages were. We would put together information about the amount of medical bills that are incurred by a client. And then we very often will actually meet with a client's treating physician, because we want to know not just what the client's damages have been since the accident, but in serious cases, we want to know, well, how are these injuries going to affect the client going forward? And the best person to address that sort of thing is typically a treating physician who knows the client, knows the injury, has worked to make the client as well as possible, but may be able to render an opinion. And typically we get it in an evaluation letter that we can forward to the insurance company. Well, how is this client going to do over the next few years as a result of this injury? Are they going to be able to go back to work? Are they going to be limited in their ability to work? Are they going to be physically limited in doing the types of things they like doing socially or recreationally? And so a treating physician it can be very helpful in projecting out, well, how is the client going to be as the years pass? And then how are they going to be as they are older person? Are they going to have arthritic development, that sort of thing? So we include all of these things in a settlement package that is sent to the insurance company. And then there's a matter of negotiation. Sometimes the insurance company will readily agree because of the information we're able to provide. And if not, we can supply other additional things. Sometimes the insurance company will say, well, we'd like to see records that predate the accident. And a lot of times we get those anyway, because we'll be able to show, well, our client treated with a primary care physician regularly before the accident and didn't have any of these problems. And it's good evidence that the accident did cause these problems. A second, a little bit more formal way that cases can be resolved is called mediation. And mediation has become popular throughout the country and in Florida over the last, I would say, 20 years. And cases are mediated by a third-party mediator, typically a lawyer who is trained in mediation, trained in how the process works, and trained in settling cases, will schedule a meeting. And both sides to the case, in our cases, we would be there, of course, with our client, and the insurance company representative would be there for an insurance company. If a lawsuit's been filed, the defendant, the person who caused the accident, could be there with their attorney and insurance representative. And so the mediator will conduct a meeting to try and settle the case with all parties present. And the mediator is a third party, as I mentioned, and is neutral and typically does not care how the case settles. The mediator doesn't care whether or not the plaintiff, the injured person, gets a lot of compensation or little compensation, and doesn't care how much the insurance company pays or how little they pay. The mediator is trained to get the case settled. And the way the mediator will do that is through a process of meeting all together, and then the parties separate and go into two different rooms. So the injured party, our client and lawyer, would be in one room, and the insurance company and the defense lawyer and the defendant would be in a separate room, and the mediator will go back and forth after that joint session in an effort to try and settle the case. And the process works because sometimes just having a third party get the message and take it to the other room, and mediators typically are very trained at helping one room consider what their risk factors are in settlement. For example, if the mediator is in the defendant's room with his or her insurance company and defense lawyer, The mediator might say, well, they make this point in the other room and they think you have a problem with this. And have you considered these risks to the position that you've taken in not settling the case? And the mediator will do the same thing in the plaintiff's separate room where we might be with our client. Have you considered this, or have you considered this? And typically through the process of the mediation, various offers will be made from one room to the other and then back to the other room. And the mediator will keep track, of course, where the offers are. And a lot of times parties can be a great deal apart. I mean, I've been to mediation where the parties were $10 million apart. And through the process of mediation, typically it just really works. And the mediator will go back and forth with offers and the gaps can be closed. Now, sometimes, even with mediation, cases don't settle because it's not the mediator who makes a decision about what the case settle for. The parties have to come to an agreement. The mediator, as I mentioned, is trained to try and help those parties see risks in their own case to get to a number that both parties will agree to. And then the mediator will write up an agreement and the case can get, a lot of cases get settled that way. The mediation process really does work if both parties come with an open mind. And judges in our Northwest Florida area almost always require mediation before parties can get a trial date during litigation. And the reason is because mediation works. It helps judges reduce their caseload and helps with judicial economy. It gets cases settled. So rather than a judge having a lot of backed up trials on his or her calendar, a lot of cases get settled through mediation. So judges typically require mediation of both parties before the parties can get a trial date. And then finally, and we're going to talk about this a little bit more on some future episodes, the last way that cases get settled is through a trial. So if the parties can't agree to a settlement on their own, if the judge requires parties to attend a mediation to attempt settlement and the mediation fails, then the last kind of alternative, final resolution for resolving cases is a trial. And in Florida, typically we have six-person jurors who are selected through a process of jury selection. A lot of folks who are watching the law show this morning have been called for jury duty, and so you'll know a couple of hundred people can be called on a Monday to attend a week of trial. And then a judge will get 30 or 40 of those people in a room, and the lawyers will ask some questions. And ultimately, you don't pick who's on your jury, you exclude who you don't want on your jury. And then you call witnesses and get a verdict, and the case is resolved by virtue of a jury's verdict. So those are the way cases get resolved in personal injury cases. We're going to talk a lot more about trials in the week ahead. So I'm running out of time for our segment of the show this week. I'm Mike McLeod here for all the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson.